Doug, phone lines are lighting up as we expected, man, because it's Ask Us Anything. So we're going to go to Susie first. And Susie, we have you on the line. Go ahead with your question, please.
Yes, I wanted to know, a will in Florida, does it have to be notarized to be legit?
Susie, great question. Doug, you want to answer that one? I think it's a real simple answer, but go ahead.
Yeah, I have partners who practice in probate and estate planning. It's not my area of expertise, but I know enough to be dangerous. Yes. And the answer is 2 witnesses and a notary, or the will is not valid.
Right.
Right?
Hey, amen. Amen. Susie, if you have questions about a will, hire a seasoned professional. We'll use that phrase one more time, Doug. Mm-hmm. You can do a lot of things and get yourself in trouble, and trying to try to save money. If you're going to some of these box stores that actually have the will kits and things like that, please don't use those, especially if you have any type of assets or any major assets. It's a great question that you asked, because a lot of people don't understand that. A lot of people understand that you don't have to have the 2 witnesses either. There's a lot of formalities in the state of Florida that you have to have in order to validate a will, because a will is a roadmap for the courts to tell the court system what should be done with the deceased property. Right. And so by all means, hire an attorney to look into that for you. Your will question, not only just getting it notarized, but making sure that you do it correctly. And if you have any type of major assets that you're avoiding, or dealing with any potential tax implications as well. So,
and Chris, people think that estate planning attorneys charge these egregious amounts. They don't. I mean, even for a husband and wife, mere wills, durable powers of attorney, healthcare surrogate, you're probably talking between $500 and $1,000. I mean, isn't that worth it to make sure your wishes for where your property is going to go after you're gone happen? Because if the will's invalid, what do? We go to the Florida statutes, intestate succession, and it says how it's going to be, and you just don't have control.
Right, and that's the biggest point. You lose control of how your assets are going to be divvied up. You have testate and intestate. If you die testate with a will, you're controlling the roadmap, and you're actually still driving the car, so to speak, about how your assets are going to be divvied up and who gets what. If it is invalidated for any reason, you fall under the intestate statutes, and then all of a sudden the state of Florida becomes the dictator of that and tells you how your assets have to be distributed. So, Susie, please, by all means, contact an attorney that you can discuss in more detail about that issue, about your issue, because answering it, you need a notary and 2 witnesses, but there's a lot more to it than just that. So.